For centuries, the printed word possessed an almost physical power. A single sentence published in a newspaper could permanently stain a person's reputation, bleeding into their personal and professional life until the damage was irreversible. Because of this destructive potential, UK libel law operated under a strict rule from the 1800s all the way to 2013, the common law presumption. The mechanics of this presumption were highly efficient and heavily favored the person sued. If a judge determined that the published words possessed an inherently defamatory meaning, the law automatically presumed that reputational damage had occurred. The victim didn't need to prove they actually lost friends, clients, or business. The court simply took it as a given. That centuries-old advantage vanished with the passage of the Defamation Act 2013, specifically due to a single provision known as Section 11. This text block illustrates the exact statutory requirement introduced by the new law. It states that a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. This single sentence ignited a fierce debate in the legal community. Did serious harm simply mean the insult needed to be more severe to qualify for a lawsuit, or did Parliament just introduce a strict new requirement to provide tangible proof of that harm? This statutory ambiguity created a massive vacuum in media law. It stripped away all previous certainty, leaving both aggressive publishers and their potential victims entirely unsure of where the legal line was drawn, until a landmark challenge forced the issue. The test case that ultimately forced a definitive ruling arrived in the form of Lachaux versus Independent Print Limited in 2019. The dispute centered on articles published by several major British media outlets, most notably The Independent. The publisher had printed highly damaging allegations regarding the claimant, Bruno Lachaux. In response, Lachaux sued for defamation, and the courts had to evaluate his claim under the newly enacted 2013 standards. After years of lower court battles, the fight over how to interpret this new statute reached the ultimate battleground, the UK Supreme Court. The responsibility of writing the definitive judgment fell to Lord Sumption, a highly regarded jurist known for his strict textual analysis. Lord Sumption's objective was to construct a precise, mechanical definition of how this threshold of serious harm must be applied in a courtroom going forward. To build this modern framework, the Supreme Court first had to publicly dismantle the lingering assumptions of the old common law system that the publishers were relying on. The publisher, Independent Print Limited, arrived at the Supreme Court with a specific, logical argument designed to protect their industry. They argued Section 11 merely raised the bar for a statement's inherent tendency to cause harm. In their view, the statute didn't change the mechanism of how defamation was proven, it just required the words themselves to be objectively worse. This left-side logic tree maps the historic baseline. Words led to defamatory meaning, arriving at presumed damage. The publisher proposed the 2013 law should look identical. On the right, words lead to defamatory meaning, ending automatically in presumed serious harm. Under this proposed model, assessing serious harm remains entirely an exercise in linguistic analysis. A judge simply reads the text and decides if the words sound damaging enough. This interpretation heavily favors publishers, limiting a trial to a theoretical debate over meaning, rather than forcing a long, expensive process of gathering real-world evidence and calling witnesses. However, this argument contained a fatal vulnerability. It completely ignored the specific past tense phrasing deliberately chosen by Parliament when they wrote the statute. Lord Sumption dismantled the publisher's argument by focusing on the exact wording of the statute, specifically the phrase "has caused." His reasoning was straightforward. Parliament would not have used past tense causative language if they intended judges to simply sit back and evaluate the hypothetical inherent tendency of words. Has caused implies an event that has already happened. This resulted in the Supreme Court's total rejection of the publisher's proposed political framework. The court wiped the slate clean to make room for a new legal reality. Lord Sumption introduced a pivotal reclassification. Serious harm is no longer a text-derived presumption of law. It is now a proposition of historical fact. A proposition of historical fact demands rigorous proof in a courtroom. It requires empirical data,
temporal evidence, and concrete documentation of events that actually transpired in the real world as a direct result of the publication. With this single classification, Lord Sumption definitively severed the centuries-old automatic link between highly offensive words and a successful defamation claim. The Supreme Court then established a new compound test in Lachaux, dictating exactly how defamation claims must now be proven. This diagram maps the new flow. Node 1 is the inherent tendency of the words, but a mandated second variable is added: actual historical context and impact. These two merge, validating the final requirement, a proven proposition of fact regarding serious harm. To validate this final node, the evidentiary burden is clear. The claimant must prove the harm actually occurred on the balance of probabilities, meaning the court must be convinced it is more likely than not to have happened. This is a rigorous forensic requirement, standing in stark contrast to the old system, where lawyers merely debated the theoretical linguistics of a sentence. The threshold of serious harm was permanently pulled out of the realm of abstract semantics and placed squarely into the realm of rigorous, data-driven investigation. To see how this empirical standard operates in practice, we have to apply it back to the original facts of the Lachaux case. Despite the undeniable severity of the printed allegations against him, Lachaux could not simply point to the physical newspaper as his sole evidence of harm. Lachaux was forced to introduce specific empirical data into the record. This included analyzing the exact circulation numbers of the articles within his specific professional sphere in the UK. He also detailed the tangible impact of those articles, proving that specific professional relationships were severed, and demonstrating concrete reputational damage among key peers who had read the coverage. Because Lachaux provided real evidence to satisfy the proposition of fact, his claim successfully crossed the Section 1.1 threshold. Lachaux proves that claimants can still achieve victory against powerful publishers, but only if they arrive at the courthouse armed with verifiable data, rather than relying solely on personal indignation. This matrix represents the simplified framework for modern defamation claims. Column 1 handles meaning assessment, and Column 2 requires evidentiary assessment. A successful claim requires both distinct phases to be validated sequentially. You need a checkmark in meaning and a checkmark in evidence. This cements a structural change in modern UK media law, establishing that a statement has a highly defamatory meaning is strictly a prerequisite. It is no longer sufficient on its own. The common law presumption of damage, the idea that bad words automatically equal a ruined reputation, is definitively dead. The UK Supreme Court's interpretation of this statute moved the legal center of gravity, taking defamation from a subjective argument over words and turning it into an undeniable empirical proof of consequences.